So let's go through some return to work and potential discrimination issues that interact with that. Years ago, we had a vocational rehabilitation system. There were no limits on the dollar amount. Some of the plans and programs that I saw were huge. They limited that to $16,000 maybe 20 years or so ago. Then they limited that again. Now we have a return to work voucher program. Now the voucher for most current injuries, probably over the last 10 years or so, it's up to $6,000 is a voucher that you get if you can't return to work. The problem is in that return to work phase, there's a lot of different areas of the law that interact, and a lot of injured workers, if they end up out of work, they feel they have been wronged. So what takes place in that timeline? The QME, or the primary treating physician, is going to fill out a return to work form. It's a form that limits work restrictions and whether the doctor believes that you can return to your usual and customary job, or whether there's some work restrictions that need to be imposed on a permanent basis. Within 60 days of that, receipt of that report from the doctor, the adjuster needs to make a determination along with the employer whether or not you can go back to work. So there's 60 days that are allowed, but this is with regards to the voucher. So there's 60 days that are allowed for the employer to meet with you, go through that interactive process, meet with you, see if you can return to work, see if there's restrictions, see if there's modifications that need to be done to your normal job, maybe an alternate job that can be found. If within 60 days, the employer can find either regular, modified, or alternative work, and the proper notice is given to you, then you don't get the voucher. So this is only with regards to the voucher is the 60-day limit. If they don't do that within 60 days, then you do get the voucher. It's up to $6,000. It's not a life-changing amount of money. So you got 60 days for the voucher. Where workers' compensation also interacts with other areas of the law is with regards to both state of California, the Fair Employment and Housing Act, and with regards to the federal law, the Americans with Disabilities Act. So in California, workers' compensation only, we have the 132A. It's a Labor Code Section 132A, which deals with discrimination. It's a little different than the federal and the state, at least with regards to the FEHA laws. In workers' comp, we're dealing with an injured worker who files or makes known their intent to file a workers' compensation claim. So the 132A violation, if your employer says, you filed a workers' comp claim, you're fired. I can't have people with workers' comp claims. That's a 132A claim. And where that varies from the discrimination laws is that under FEHA and the ADA, they're generally dealing with people with disabilities. So you can have a 132A violation necessarily, or not necessarily, with a disability. If you're fired simply for saying you're going to file a workers' comp claim, that will be a 132A violation. You don't even need to have disability. Maybe you'll completely recover if you were injured. Slightly different, the FEHA, the state law, and the ADA, the federal law, those deal with discrimination. Those focus more on the interactive process. They focus on accommodations that the employer should make, whether or not they're reasonable. And quite honestly, I don't get involved in FEHA claims or ADA claims. I'm a certified specialist in workers' compensation, so I'm very up to speed on 132A claims. I am not up to speed on FEHA and ADA claims. So when my clients come to me, the doctor found that there's permanent work restrictions, they can't return to their normal job. If my clients feel that they have not been properly treated by their employer, I will generally refer my clients out to an employment law attorney or a labor law attorney. So I'm a certified specialist, workers' compensation. It's a very closely related area of the law with labor law and employment law, but it is different. So we only deal with workers' compensation. And a lot of workers' comp attorneys are in the same boat. They simply don't get involved in FEHA claims or ADA claims. So for those questions, did my employer discriminate against me? Was this a reasonable accommodation? I generally refer my clients out to employment law attorneys who specialize in that type of area of the law. So that's a quick rundown, some of the issues with return to work, permanent work restrictions, the job voucher, 132A violations, FEHA violations, and ADA. Very complicated area of the law for probably a 5-minute talk. But if you have further questions, drop us a comment down below. And if you found this video helpful, hit the like button.